Hello, my name is Casey Lee, and I am a staff attorney at the Legal Aid Society. I'm here to talk about New York State Surrogates Court. In this video, we're going to cover some important information about Surrogates Court, what it is, and how it helps individuals and families navigate legal matters related to the estates of the deceased. Whether you're dealing with a loved one's estate or preparing your own will, understanding how Surrogates Court works can be crucial. Here are 5 things you need to know about Surrogates Court. What is Surrogates Court? In New York State, Surrogates Court is a specialized court that decides what happens to the property of a deceased individual or the decedent. Surrogates Court helps families manage the transition of assets and responsibilities after someone passes away and resolves any disputes between parties. In Surrogates Court, the judge is called the surrogate, and the property of the decedent is called their estate. Family members who are entitled to a share of the decedent's property are distributees. This video covers the 3 types of estate proceedings that you may file in New York State Surrogates Court. If you are handling the estate of a deceased family member, the type of estate proceeding you file will depend on your individual circumstances. Probate proceedings are filed when the decedent left behind a will, which the court must review and validate. Administration proceedings are filed when the decedent did not prepare a will, and the court must appoint an administrator to distribute the estate. Small estate proceedings, also known as voluntary administrations, are filed when the estate of the deceased is worth less than $50,000. When a person dies with a will in New York State, the will needs to be filed in Surrogates Court and approved for probate. Probate is the process of proving the will is valid. Once the surrogate is convinced the will is legally acceptable, the executor named in the will is appointed to give out the decedent's estate according to the will. To start a probate proceeding, the person named as executor in the will must submit the original will without removing staples, a certified death certificate, and a form called a petition for probate to the Surrogates Court in the county where the decedent lived. The probate petition must also list the decedent's distributees or heirs. All of the distributees will either need to sign a waiver of citation or be served with notice of the decedent's will and executor's filing to manage the estate. If the court determines that the will is legally acceptable, the court will issue letters testamentary, which gives the executor authority to distribute the estate. The executor is responsible for gathering the decedent's assets, paying any debts or taxes, and ultimately distributing the remaining assets to those named in the will. When a person dies without a will, they're said to have died intestate. In that case, the decedent's relatives must start an administration proceeding to legally collect and distribute the estate. Typically, the heirs or distributees closest to the decedent, such as a spouse and/or children, will inherit the estate. To start an administrative proceeding, the closest distributee must file a copy of the paid funeral bill, a certified death certificate, and a form called a petition for letters of administration to the Surrogates Court in the county where the decedent lived. The petition must also list the decedent's distributees, as they must sign a waiver of citation or be served with notice informing them that a family member has filed to be appointed administrator in order to manage the estate. Once the court has issued the letters of administration, the administrator must manage the distribution of the estate. Like the executor in probate proceedings, the person appointed as administrator is responsible for gathering the decedent's assets, paying any debts or taxes, and giving out the remaining assets to the distributees in accordance with the law. When a person dies with less than $50,000 of property, regardless of whether there was a will or not, their estate may be considered a small estate proceeding or a voluntary administration. A small estate cannot have real property like a house or land, but keep in mind that jointly owned property may not need to go through Surrogates Court. To start a small estate proceeding, you will need to submit a form called an affidavit of voluntary administration. Please visit the New York Court's website below for an online guide to generating the affidavit that you will need to file in your Surrogates Court case. Surrogates Court is an essential part of the legal system, ensuring that the estates of deceased individuals are handled properly and fairly. The process can sometimes be lengthy, especially if there are disputes or complicated financial matters involved. Whether you're probating a will, administering an estate, or dealing with a dispute, understanding the process can help you navigate this often complicated area of law. For further assistance, call our Access to Benefits A to B hotline, 888-663-6880, Monday through Friday from 10 a.m. to 3 p.m. And be sure to visit our website at legalaidnyc.org/get-help to view all our resources.